The first point my lords heard me on is the heading, EC's power under 324 is circumscribed by 327. Broadly, that's the Election Commission's power under 324 operates within the framework enacted by Parliament under 327. Parliament has occupied the entire field through the ROPA and the rules, that is RER. Once the legislative framework prescribes 4, 6, and 7 as the only permissible forms, the ECI cannot, through executive innovation, introduce new forms not contemplated or authorized by statute. ECI cannot use its non-existent executive power to operate in the interstices where parliamentary law already exists. Now the submission, brothers and facts. Neither the original enumeration form and the declaration form, nor the modified version introduced or exist anywhere in the RP Act or the RER. Such form could be prescribed only by delegated legislation under the Act through parliamentary law in the form of rules. This innovation has come in June 25 for the first time. SIR is an attempt by ECI to bring it under the fold of its plenary power under 324. Note, para 85 specifically locates its power under 324. Para 85 of their counter. They say this is our power.
Actually, you read last time you read.
Yes. So I'm just reading through it very quickly. By introducing enumeration form and declaration, ECI has acted in disobedience to the mandate contained in the Act. Once parliamentary legislation occupies the field, that has to be followed. That is why I cited AC Joe's Balos, which is directly contrary to para 85 of their counter. AC Joe's, I will not trouble Lordship is read. Just see the 3 lines extracted in para 25. Of course, the 22 and 25 are both relevant. My Lord has marked it. 22, Your Lordship may mark on the side. Where there is an Act and express rules made thereunder, it is not open to the Commission to override the Act or rules and pass orders, direct disobedience to the mandate. The impugned exercise is an overreach. This part I have covered, brothers, and Lordship will note 22 along with 25. Now, brothers, the second aspect, scheme of the Act envisages an individuated exercise through Form 7. This is a very important point. It's a more abstract point, but brothers, your Lordship has really got a problem here, according to me, because everything is on a massification basis and not on the concept of the Act and the rule, which is individuated. That's the point I'm trying to develop. By introducing a new form requiring submission of 11 documents, ECI has assumed a rule-making power not conferred by Parliament. No statute or rule authorizes ECI to require documents such as birth certificates. This constitutes determination of citizenship, an area over which ECI has no jurisdiction. Today, Madam. Well, today, just pause for a minute. Till June 25, your Lordship had the forms, right, Malas? In June 25 came a new 11 document system. So let's call it the pre-11 document system and the post-11 document system.
Yes.
Malas, prior to June, your Lordship had, let us say, X document system, just call it. After June, your Lordship had a Y document system. Now, Malas, unless this power is trammeled within the contours of the Act and the rules, nothing prevents them next year to have a Z set of documents. Ethnicity. I'm not saying it will happen. I'm testing the proposition. Ethnicity, race, subdivisions not only by parent 1, parent 2 and yourself, but subdivision by grandparents. So, Malas, these are new systems where a parliamentary law is occupying. Kindly go further. ECI's power to determine citizenship is limited only to individual cases, and only such bilateral inquiries are in its remit. The entire structure of the Act and the rule is bilateral or trilateral or quadrilateral or quinquennial. It is not 7 crores. It is not 6 crores, 5 crores, each state. To the extent the Parliament intended ECI to satisfy citizenship requirement, it did through Form 7. My Lord has a Form 7 already. Nobody is saying that Form 7 is not there. Any extension of that is invalid. this I have argued, Manoj. ECI is essentially declaring everyone between 2003 and 25 as a temporary guest who can only remain in the rule through a citizenship test through the 12 enumeration documents, which are themselves not part of the statutory forms. ECI has no power to do this as 324 is trumped by law made under 327. That's the constitutional or legal proposition. ECI has extended its limited power into a broad, unprecedented exercise, bypassing the rigor of 327 and therefore affecting entire populations. Each of the SIR exercise, there is no SIR exercise which is constituency-wise, area-wise. It is all state-wise. I'll deal with the argument of constituency in a minute, but just leave that aside. No exercise. The entire thing is, only thing it is not all India at one go because they can't logistically do it. So it's state-wise and big states. ECI has extended its limited power into a broad, unprecedented exercise, bypassing the rigor of 327 and affecting entire populations. Each of the SIR exercises is all state encompassing, clearly raising citizenship issues. In stark contrast to the individuated, bilateral, and quasi-judicial approach of objections to an individual case. Well, it's quasi-judicial, individual, reasoned orders, opportunity of rebuttal, and a quasi-judicial decision thereon with reasons, it should be plural, in turn subject to a potential challenge to an appeal. Such an expansion has never been contemplated or undertaken in our constitutional framework. This part, I had broadly orally argued till now. Now I come to the third part. 21.3. Now, let me just take 21.3 because this is the last part of my argument and I'll be done with that. Just take 21.3 of the Act. There are 3 or 4 or 5 points I want to make on that.
That very small provision that could be added here only in the note. 21 you could add, probably your assisting counsel should have added here only. That could help.
Sorry. Well, I actually am going to refer to some other parts of 21 also. So it's, well, I may have to refer to other parts of 21, so it will be longer than just the 21.3. Maybe longer. But I should have perhaps.
It's in true sense a brief note only. It's not a very lengthy note. Right?
No. It's very brief. You have been kind enough to hear me last time at length. I'll just finish in a short while. Well, let's just give the Act to my lords. Now, 3 or 4 points. Well, your lordships have said all statutory interpretation rules are contextual. Your lordship knows or becomes and becomes or. All that depends on the context. I'm now trying to cull out 4 or 5 contexts from section 21 as a whole and 21.3 in particular to say that the approach has to be bilateral, individuated, quasi-judicial and reasoned. Can't be en masse. It's an en masse. Let me point out that. First, let's read 21.3. Non-obstant, notwithstanding anything in 2, the Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency or part of a constituency in such manner as it may think fit. Lordship, just note my bullet arguments. Ultimately, it's for my lords to consider. Argument number 1. The structure of this section is clearly for any constituency or part of a constituency, which must be read as a composite phrase. Any constituency or part of a constituency must mean individuated, constituency-wise, or 4-5 constituency-wise approaches. It can never encompass a all-state en masse approach is my first point. I hope I'm clear with this. Second, any here in context cannot mean all. My Lord Justice Bakshi put to me a direct question. Because it's context. It can mean all. Any can sometimes mean all. But any cannot mean all in this context. Otherwise, the phrase constituency or part of a constituency would be meaningless. There can't be any or part of all constituencies in India. For that matter, pan-India, forget pan-state. Third, just go a little bit more detail into this verse. For reasons to be recorded. This has to be an individuated. Your lordship has a quasi-judicial approach. I'm not a judge and a reasoned order and all that, but the idea is that in one case, two cases, three cases, you will have a back and forth. I will give objection, she will give reply, somebody will give reasons, and then your lordship will decide. I mean, that person who will decide. There cannot be for reasons to be recorded on an en masse basis. The very idea, the very structure of the provision is individuated. That's the third clue to context. Your lordship is looking for clues to context as to why any constituency or any part of a constituency does not mean all, cannot mean all. The fourth, proviso is important. Does my lord have the proviso? I'm giving your lordship different clues to context, why any cannot mean all. Provided that subject to the other provisions of this act, the electoral roll for the constituency as in force at the time, the electoral roll for the constituency, that constituency or a part of it, shall continue to be in force until completion of the special revision. The idea was that you may need special revisions for certain situations for an individual constituency or a clutch of constituencies. Not an en masse, all state, all India. 1 minute. Fifth reason. Your lordship notes non-obstant is only to 2, not to 1. So 3 overrides 2. My lord has noticed that. That means, Wallace, the first part can operate in the prescribed manner, untrammeled. It can't be by another manner. Read the first part, Wallace. The electoral roll for each constituency shall be prepared in the prescribed manner by reference to the qualifying date and shall come into force. Well, the prescribed manner, we all know it's already there. You cannot have an electoral roll other than the prescribed manner.
Yeah.
And in case you locate your power, as the Election Commission is doing, in 21.3, I'm not accepting it, 21.3 is only constituency-wise or group of constituency-wise. But in case you locate it for en masse power, then 21.1 remains untouched. 21.1 remains untouched. In advance, you tell me tapering.
Even if we say that in that any individual payment manager chose intensive witnessing banking.
Tell me the tapering way. Don't tell me suddenly. You get water immediately. 8 minutes last time. Huh? How many minutes?
Say, is it likely to repeat what you say? This is scary.
I mean, all these.
Yes. So you could say that.
So इसमें तो तीन लिखे.
ये आप गलत कर रहे हैं. टाइप करके. You should send this to the court master. Right? It's not his job to notice. ये नहीं गया ऐसे. ये पहले आएगा 27 ही बाद में आएगा.
27.
हाँ, ये क्या है? Who the hell is this?
So describe what talking about isn't finished at 5, that is revision of force, and it can be intensive summary. This is the provision that provides for the kinds of provision.
इसके बाद कुछ नहीं पढ़ना है सिर्फ.
It shows intensive.
But tell you one thing, these cases में कौन सा पढ़ना है?
Any wala is not required here.
सहरादी सरकारी.
नहीं. Any wala you should pay. Any be seen in the context. Khode wala you can show that citizenship can only be determined. Point English.
That's correct.
Rajiv Gandhi, the citizenship letter, so this
You
is
just
citizenship.
double tick that which has to be read. So double tick it right now. And have you noted it like this? You should put like this correctly. 5 points contextual. I want to remember it like that. In the new paper, write down 5 in that order. 1, write down. 1, any does not mean all. 2, structure of constituency or any part of constituency. 3, the constituency in proviso. 4, non-obstant only over 2 means 23(1) will apply as per prescribed. 5, 25(1) prescribed is 23(1) prescribed is 25. Huh? 21(1), sorry, is as prescribed in
Rule 22.
rule
22. Varia. Rules.
plus A. Let's take the other paras.
इसके preparation, which is about how you will see the electoral or political. This provision.
ये तो पूरा पढ़ लूंगा मैं.
ये नहीं touch किया अभी तक. This is not electoral. Any
ये
you go back. Who does resolution for this? Things are the
only time it is done
only one.
and where the individuated will done. Huh?
Yes.
For all these
No, only one.
all these 15,000 persons.
15,000 people deleted, 21,000 added. Of a particular community deleted.
Did they do it for all 40,000 people?
The entire constituency did it.
Especially पहले भी हुआ है बंगाल में 2003 में क्या होता है?
Special revision of intensive nature. So special revision, which is Shahrukh ka point hai, if you're choosing intensive from 25 gives options.
So Malas, I hope my lord has noted my 4 or 5 points. The 5th point, the last point, relates to 21(1). So you can do it because that's not non-obstant to 21(3). You can do it only by the prescribed manner. In 21(1), the phrase is prescribed manner. Where is the prescribed manner, Malas? In Rule 25. Just glance at it. Just glance at Rule 25. So the prescribed manner, which is not trumped by 21(3), is in 25 rule. So there's a harmony. Now, Malas, today you are reading it to mean en masse. Any means all constituencies. These are 5 clues as to why the context cannot mean this. Then, Malas, I will just wind up on this note. Kindly come back to my section C. C3A1. But don't read it, just let me explain, Malas. Actually, Malas, I've checked up. I've instructed my learned
You are referring to your note now.
note. So the rest above that is done,
No,
Malas.
C.
C is what I've just argued, though not in that manner, Malas. I put it in very specific terms, 1, 2, 3, 4, 5. 5 clues to interpretation of 21(3) is what I'd like to call them, Malas. Your Lordship has noted those 5 clues. One is any, should not be all. Second is, Malas, the structure of the word constituency or any part of the constituency will be distorted if your Lordship says all. Third is, the proviso says the constituency. Take out Rule 25.
Yes.
And the fourth is that the non-obstant does not trump
Reasons to
one.
be recorded. Fourth is reasons to be recorded.
I'm very grateful. I'm very grateful. Your Lordship, I was going to put it lower down. That's very important. That should come higher. Reasons likhiye.
Given.
Write down here. Reasons to be
The fifth
recorded.
you say is the non-obstant.
Yeah. So I'm not put it like that. Therefore, in oralizing, I left out that.
Yeah.
Reasons has to be always by very nature individuated. There can't be a one size fit all.
Dr. Singhvi, to further reduce the argument to its nucleus,
Yes.
it's the connection between the word any is the reasons to be recorded.
I'm very grateful. No, that's a better way of putting it. That's
So,
the
so the
causal
nexus for 21(3) to trigger in
yes.
is a reason
Yes.
which is relevant for any constituency.
So, Malas, that
And
would,
those constituency, that may be one or many, would come within the special revision.
I'm
That is how.
very grateful, Malas. That would be
Student.
additionally a seventh reason.
Sub constituency में
It's there in the most.
Maybe not this, what he's saying.
It gives the context. Reason given by them is rapid urbanization, frequent migration, and that they have constitutional obligation.
So, Malas, the sixth part is reasons generally. Reasons can never be one size fit all. Reasons have to be individuated, specific. And Malas,
so far you have not attacked on the reasons, that the reasons are only for a specific constituency or for two specific constituencies. So if the reasons are common in the sense that those reasons attract to every constituency,
yeah,
then whether the expression.
I am coming to that straight away. Malas, just to let me go out of sequence. See the last para, number 4 in that para, in the note. This cannot be the intention of 21.3 is my argument. The reasons given in the order are rapid urbanization, frequent migration, and Commission has constitutional obligation, para 7 and 8. Now, Malas, according to me, it makes a mockery of 21.3. This was lots of interpretation ultimately. 21.3, if it has to have any meaning, where is the quasi-judicial? Where is the individuated approach? Where is the causal nexus between reason and any? And Malas, even within generic reasons, they are the most generic of generic. Rapid urbanization and frequent migration. In fact, India is no more rural and urban. More than 10 years ago, Malas, we have become rurban. The word is rurban. When your lordship travels from Malas X to Y, you don't know when Malas rural, purely rural, it turns into rurban really last, and then comes to full urban. But Malas, rapid urbanization can't be a ground for the 21 construction I am canvassing unless your lordship takes it to be a completely generic provision. In which case the language of the provision will not fit in. Frequent migration, as generic as can be, Malas. So this is the totality of the reasons the lordship must interpret 21.3 in its proper form. Last point in that is 21.3 takes you to 21.1, which is the prescribed manner. In the prescribed manner, your lordship will add Rule 25, which is the actual prescription. Revision of rules. Just note it, don't read it. It says revision of rules, Rule 25 of the electoral rules 1960. So 21.1 prescribed manner is Rule 25 of the 60 rules. Now, let's.
Dr. Singh, it is your argument that a special intensive survey has to follow the prescribed manner under Rule 25, or there is a residual discretion left in relation to the visions given for the special intensive survey to cut the cloth according to the requirement.
Yeah.
Why we ask you this question is,
yes, listen.
The words used in such manner as it deems fit and proper. So, will that totally obviate the jurisdiction of the Commission to maybe tweak certain areas in the scheme in which it undertakes the special intensive survey to achieve the goal which is articulated in the reasons? Will it be unconstitutional or ultra
The very direct question deserves a direct answer, Malas. The answer is largely no. You don't have the power. Why no? Ultimately, that power starts from the bottom at Rule 25, goes up to Section 21. If my interpretation of 21 read with 25 is correct, then they have limited power constituency-wise. That's the first answer. I will not repeat the 5 points. Second, when a particular, there are extraordinary circumstances do arise, and your lordship will not find them inhibited to act on that. As I'll give an example, the only time in history when an actual SIR has been done. All the others are not SIRs. They are revisions of an intensive kind. The actual SIR happened only once in a place called Thakurdwara. There is no limitation because you are doing it under 21.3. Now come to my para in Malas 3A1. 3A1. No, I don't mind they do SIR in places like that.
Let's assume that you have that power. The minute they choose,
Fine.
when they choose utensil, then they're submitting to them. They chosen utensil in this case. That word is in here, nobody else.
Note down here, you're not noting down the orally निकलना note करते हो. Intensive words use करते हैं. They're limited to 25. That's the only place the word is in same place.
That's it. That's why they chosen to prescribe and chosen to submit the argument of this case.
निकालो 25 में निकालो line. Keep it open here. Let us take it out because
State said who finds a petition
underline there.
intensively, really, partly intensive, partly summary.
So even if they have power, it means
Especially
X-ray,
in
if they choose it.
this manner, you are limiting intensive.
They wouldn't choose X-ray as they choose utensils.
Now, there is another answer to my Lord's case. It's very useful because we can think it out as your Lordship puts the question. This is a rule. What my Lord has just mentioned is a rule. Obviously, it can't travel beyond the act. The rule itself says the word either intensively or summarily.
Sub-rule 2 of 20.
One rule, rule number 1.
One.
Rule 1. And it uses the word intensively directly here. So whatever you do calling the word intensive will have to come and subsume and follow 25 in some form or the other. Because it's an entire coverage. The role for every constituency, and mark the word between any and every. The role for every constituency shall be revised under 21(2), which is non-obstanted by 21(3), either intensively or summarily. Now, Malas, you cannot read the 2 points, Malas. Point 1. Whenever you do something which you call intensive, it has to conform to 25. Because 25 is the only place where that word is directly used. You can't take leave of 25. Number 1. Number 2. 25 can't travel beyond the section. "25 cannot travel beyond the section." Now, Malas, your Lordship's concern for a constituency which warrants this kind of intensity is given in my Thakurdwara example in Uttar Pradesh. Malas, what happened in Thakurdwara was that 15,000 persons of a particular community were deleted and 21,000 of another community were added. They did this very exercise. They inquired and they passed an order. Turn to 141 where the order is there in my compilation. It's exactly what you're supposed to do. You've given this compilation? We hand it over. 141. Nobody has any problem with this. It's a detailed inquiry committee, an inquiry and a reasoned order, which is at page 141 of my compilation. Chief Justice will have it for this. Never before has this massification of the entire state by state happened. This is an example of individuation. This is an example of application of mind, reasons, causal nexus. See para 3. The inquiry officer visited Unnao and look at the dates. There are so many days. The inquiry did not show any irregularities in the law. The inquiry revealed a shocking state of affairs in as much as the names of more than 15,000 persons to a particular were deleted. So this is a individuated example of en masse. Very interesting contrast. Within the individuated example of Thakurdwara, you have en masse deletion and en masse addition. Without following procedure, subject to Lal Babu Hussain, abnormally large number of 21,000, another community included without proper. The full commission has, after taking into account the inquiry report, all of the relevant factors, unanimously decided to order a special revision of an intensive nature of the electoral roll. This is the... Well, nobody in 75 years has thought of this brainchild with great respect. If I was to pay a left-handed compliment to the EC, this is malas, truly a new innovation by the EC. Whether it is left-handed or right-handed, malas, they will judge.
Action is taken against those people.
Nobody has ever thought of it. And then at 141, malas, they took disciplinary action against the people.
Yeah.
And that's all right. We are not concerned. This is the meaning of malas. You have a problem, you're a serious kind. You're not powerless. But you are using a power which doesn't exist or is intended for something else, for something totally malas, ulterior and different. Then malas, I now come to malas. Just see malas, small 4 and 5, which are general cases on any. Any contextually would mean individuated. But I'm not saying Lordship is bound by them. Ultimately, malas, these are cases of the beauty about malas, statutory interpretation is that Lordship interpret whichever way a Lordship malas finds the context. But the cases I've given, any depends on the context and has been held to mean malas, a restricted meaning. These are the two cases. Now come to a very important part, malas, of one part and then the most important part, citizenship. First, malas, Article 14. This point is very quick and short, malas, but I must digress for us 2 or 3 minutes, malas. Well, Article 14 has a very fascinating article. If somebody was asked which is the most important article in the Constitution, at least personally, I would say not 21 but 14. Some people will say 14 and 21, no problem, malas, both are very important. 14 till malas Royappa, and Royappa was Chief Secretary of West Bengal, malas, had the anti-discrimination facet only. My Lord Chief Justice knows the old cases, malas, of anti-discrimination. Chiranjeev, Dalmia, all that, Tendulkar Commission. Classification doctrine. In 1974, Justice Bhagwati established for the first time anti-arbitrariness. So, of course, as in many of Justice Bhagwati's judgments, Royappa lost. But in losing, he became a martyr and established anti-arbitrariness. Then, malas, from 74 till the 80s, you had a slew of cases which expanded anti-arbitrariness. Malas, Ajay Hasya, Airport Authority, Shetty, Maneka, etc., etc. So many. So Justice Bhagwati firmly established and embedded a facet which was not there for the first 25 years of our republic. Not conceived of. That's why I'm saying it's a very developing one, it's very important for our case. Third stage of Article 14. In Maneka, we did actually due process, malas. But malas, we paid lip service to what Mr. B.N. Rao had intended and said this is only procedural due process. So Maneka was put in a slot called procedural due process. Because, as your Lordship knows well, Mr. Rao went abroad, he met Justice Frankfurter. Frankfurter was sick and tired. He said, do what you like. Don't do due process phrase in your constitution. So our original 21 formulation was changed to a phrase from the Japanese constitution, except in accordance with procedure established by law, and due process deleted. Because due process deleted, Maneka was slotted into malas, procedural due process only. And then comes the fourth and the most important part of expansion of 14, which is manifest arbitrariness, which is full substantive due process. Whether your Lordship likes it or not, whether Mr. Justice Frankfurter is turning over in his grave or not, malas, it is Shaira Bano, that malas, triple talaq, that adultery case, Swiss ribbons, any number of cases, malas. It is substantive full due process. Let us not make a, let us not ignore that part. So today, it's a very potent anti-arbitrary, anti-discrimination, procedural due process. Here, malas, if you create 3 sub-classifications, as you've done in this case, not only one classification, 2003 versus post-2003. That is classification 1, pre-2003 versus post-2003. But post-2003, 3 classifications further. We are not talking law, malas. We are not talking whether they're insisting on it or implementing it or not. That's not the point. Your Lordship may have stepped in, will not change the law. The law is, this classification is clearly hit by 14, the original 14. There cannot be a nexus to any basic public interest object to be achieved by saying that post 2003, my learned friend will produce both parents, she will produce one parent, I will produce only myself certificate. 3 sets of certificate. Apart from the impossibility in many cases, that's a separate argument. So that's my Article 14. I cited the famous Anwar Ali Sarkar Malus, which is actually
Yes.
way before Article 14 became what it is now. It's the first case actually. But this is Malus completely a violation of this classification has no reasonable nexus to any public interest sought to be achieved. Please tell the court what is the overriding public interest you will achieve by having three classes of people even after 2003. I am objecting to pre-2003 and post-2003, forget that. But even after 2003, there cannot be any reasonable nexus. And last, Malus, but probably the most important, which I have not addressed at all, is the citizenship test. ECI has no plenary powers under 324 to conduct a citizenship test by introducing arbitrary procedure in the guise of SIR. ECI is a constitutional body under 324 tasked with superintendence, direction and control of elections. However, determination of citizenship status lies exclusively with central government under 8 and 9 of the Citizenship Act or with the courts of the Foreigners Tribunal Act. By requiring EROs to scrutinize citizenship documents, mark suspected non-citizens, that is what is actually happening, or report them to the Home Department, the ECI has acted ultra vires the Constitution and the Citizenship Act, effectively creating a parallel mechanism of citizenship determination through an electoral process. This not only breaches statutory limits, but raises concern of indirect NRC, etc., without parliamentary sanction. The burden, now this Ghodewala case is a little interesting. I'll just read these two and I'll end, Balas. The burden of establishing citizenship rests with the state and not on the individual. The determination or assessment of whether a person is an Indian citizen or not can only be done by the central government. Mark the word, this is Justice Bhagwati's word, only by the central government as per procedure established by law and not by ECI. Whereas here the ECI does two things. It presumptively puts me on a temporary citizenship list. It's my language, it's not their language. The original list I come on is a presumptive temporary citizenship list. And then largely, second error, I have to prove that I am a citizen and not any other way around, that she has filed an objection against me and that we have an adjudication. No. So this is, Malas, very serious. You have arrogated to yourself a power which doesn't exist. You have made a temporary list. You have created a presumption whereby you are in fact putting the burden on me. All three errors lie in my para 3, Malas. Then lastly, Malas, the well-known case, Lal Babu Hussain. Presence on the electoral roll is prima facie proof of voter eligibility, including citizenship. And the burden of proving otherwise lies on the objector. You are reversing this burden. It's not a small thing, but it's very easy to pass it away. Or on a new voter. ECI must attach adequate probative value to the immediately preceding ER in Bihar and entertain all their effects, etc. Just read two paras and I'm done, Malus. Come to the Ghodewala case. Give it. Take it in this compilation. 103, just one para, Malus. Take it out.
Starts with 103.
103 minutes, yes.
It starts. Which paragraph?
Apparently, this gentleman was called Ghodewala. Para 11. Yeah, that's right.
112.
Just relevant. May I, Malas, come to the relevant portion to save your lordship's time? Come to page 113. It's part of para 11, but 11 is a long para. And if my lord will come to page 113 as part of 11.
Yes.
If my lords have it, I'll just read it. May I read? Fifth line on 113. A man may not be a citizen of India because he has not acquired the citizenship of India at all, or having acquired it, he may have lost it by voluntarily acquiring the citizenship of another country. For purposes of deciding the question, this is where I want to start, fellas, arising under 9.1, the central government, by virtue of the power conferred by it on 9.2, has been given an exclusive power, please underline the word exclusive, to determine in accordance with the rules of evidence provided for the purpose whether a person has acquired citizenship of another country. It follows that once a person is admitted or held to be a citizen of India, unless there is a decision of the central government under 9.2 of the Act that he has acquired the citizenship of a foreign country, he should be presumed to be an Indian citizen. Now somebody can point out that that I'm wrong. Section 9 is a complete code as regards termination, etc. May I skip 4 lines and come, Malos, to we are concerned? 4 lines later. We are concerned here with the case falling under clause 2. Clause 2 above is Malos voluntarily acquired the citizenship of foreign state. And that question has to be decided by virtue of Article 11 and Section 9 by the central government only. Earlier exclusive, now only. The policy behind 9.2 appears to be that the right of citizenship of the person who is admittedly an Indian citizen should not be exposed to attack on all forums. Mark the word, in all forums. ECI is only a forum, Malas, for this purpose. Should be decided by one authority in accordance with the prescribed rules that every other court authority would have to act only on the basis. And last, Malas, but not the least, Malas, that para 5 and particularly 6 and 13 of Lal Babu. I have read to your lordship. That is extremely important. Your lordship is rising. I'll not read it. Clearly says that you can't get into at 118. Just glance at it and I'll leave it there. At 118 it starts. At 130. Sure, please.
Thank you, sir.
130. 118 it starts at 130. Directions are enough, Malas. If any person, para 3 and 4. If any person whose citizenship is suspected is shown to be included, the electoral registration officer, any other officer, shall bear in mind that the entire gamut for inclusion of the name in the roll must have been undertaken, and hence adequate probative value has to be given.
130, which serial number are you referring?
I'm sorry, 3 and 4. Earlier para. Iske baad wo para. Entire shall bear in mind that the entire gamut for inclusion in the name of the electoral roll must have been undertaken, and hence adequate probative value be attached to that factum before issuance of notice and in subsequent proceedings. Here you first put me on the list. Where is the notice? You put me on the list already, which I called a guest list last time. The officer holding the inquiry shall bear in mind that the inquiry being of quasi-judicial nature, he must entertain all such evidence, documentary or otherwise, the affected person concerned may like to tender in evidence, disclose all such material on which he proposes to place reliance. So the person concerned has a reasonable opportunity of rebutting such evidence. The person concerned must be remembered, must always have a reasonable opportunity of being heard. Malus, I'll not read more, lordship is rising, but the discussion in the earlier paras, Malus, 6, 5, 6 and 13 may be noted. And I'm deeply obliged.
Thank you. Thank you.
Well, I'll give the appearance. I'm appearing for 5 matters, Malus. Some set of 7 political.
That your assistant consul.
I will give that to the court.
Malad, may I mention, Malad, the Nagpur High Court Bar Association matter yesterday, which your lordships heard, Malad. The order may be kindly uploaded. That's the only prayer I have, Malad. Item 1, code 1, item 48, Malad, yesterday.
I will do that. We'll do that.
Deeply obliged.
Mr. Jain, that there are 2-3 matters because पहले बताने क्यों तो matters को discuss करो. इसके फिर
All yours. The other side is mentioning, I have to respond if required.
Malad,
immediate after lunch. We may start after maybe 15 minutes.
Please.
Malad, only 1 second, Malad. In this matter, because our turn will not come today, Malad. There is a planned attack on the BLOs in Bengal, Malad. The lordships have seized the matter, but still, Malad, there is a threats, intimidation, and attack on the BLOs, Malad. So this is the 1-page note, Malad. I was to please pass on it.
Attack where?
This is 1-page notes, Malad. It's a time, Malad. Election Commission should requisition the police, Malad.
I'd mentioned this
is-
yesterday, my lords, in the context of one of the
Because
other states.
Generally,
Same
Malad,
issue.
please allow me.
Same issue.
Yeah.
Same issue I'm supporting.
Okay. Malad, generally the police comes under, Malad, the ECI after the model code of conduct, because this process is also part of the free and fair election, Malad. And there is serious threats. This is published, Malad, on the front pages, Malad. So
Don't worry, the authorities will take care. Like there is there is a system to maintain
Well,
law and order, they will take care of that. We'll take up the left out matters where urgent and time bound matters quickly, where some direction might be required to be issued for 15-20 minutes, then we'll take up this.
I'm only requesting, my lord, the ECI, my lord, ECI should do something, my lord. We are BLOs are
We are coming back, we are coming back.
obligement.
Item,
37.5.
what is the item? Subvention.
It is yet.
Subvention matter.
It's already listed today, not 37.5. Listed, these are 5 matters listed at 27. Representing the vendors.
Item 37 has nothing to do with subvention. What is this matter? Just a, we are coming back, we'll take up some of the matters.
Only one, there is a small.
Order.
We are coming back, we are sitting before 2 o'clock after the lunch. Kerala matter, we can't take up first, this matter is going on. Because you are wanting deferment in that prayer of a deferment. Already after lunch you point out.
My accommodation is. You will be measuring for Lordship, my accommodation is my accommodation.
For 37, are you mentioning after?